Hello? No, you've got the wrong phone number. Stop calling. It's a fake law enforcement unit that's trying to raise money, and it's not a real, I mean, it's a scam. It's like the third time in 2 months.
Wait, I lost my pen.
Here.
Oh, do you see it? Oh, you're the best. Thank you. Just for that, I'm going to decorate your office. Bird in here. Moth, yeah. It's huge.
There are those. Good morning, everyone. These are the detention hearings for the 323rd Judicial District Court of the State of Texas, Tarrant County's assigned juvenile court. In keeping with the spirit of the open courts provision of the Texas Constitution, these hearings are being broadcast live on YouTube. I'll remind anybody who may be watching these hearings that rebroadcasting or recording all or part of these hearings is expressly forbidden. Violation of the court's order may subject you to civil and/or criminal contempt proceedings. The purpose of today's hearings is not to determine whether or not the child actually engaged in delinquent conduct. Instead, the purpose of today's hearings is to determine whether or not the child, whether there's probable cause to believe that the child engaged in delinquent conduct. The law allows me to make that determination based on hearsay evidence provided to the court through the form of police reports that have been provided to the probation department, which are then provided to me. If I make the determination that probable cause exists to believe that the child is engaged in delinquent conduct, then I will proceed to a second determination of whether or not the child should be ordered to remain in detention or be released to a parent or guardian. In making that decision, I am instructed by our Texas legislature to consider 5 different factors, and I will do so in accordance with state law. To each of the kids who are here today, each of you has the right to remain silent and not say anything at all during these hearings. Anything you say at a detention hearing cannot be used at an adjudication hearing, modification hearing, or disposition hearing. However, we have a representative from the district attorney's office taking notes, and anything you say, even if you think it might be innocuous, might lead the DA's office to find additional information that they could use against you. So instead of just blurting something out in the middle of the hearing, talk it over with your attorney first. That way he or she can advise you on whether or not you really should say it. In each of your cases, I will appoint an attorney to represent you during this hearing. All right, first on our docket this morning is Joshua Pierre Kane. Mr. Kane. Mr. Houston, what brings Mr. Kane to court today?
10 days
Yes, sir. He is level 1 acceptable today, is that correct, sir?
Yes, sir.
All right.
He had initially signed a waiver on yesterday and last night.
Oh, all right. And so the court has previously found that probable cause exists to believe that you've engaged in delinquent conduct, so I won't go into the underlying allegations against you. Judge Kim has already made that determination. I will continue that for today. Man, level 1A. What does Judge Kim require before I can consider you for release? Outstanding, right? Oh, man. So what do I got to do today? You understand. We got rules, right? We got to follow the rules. We got to be the same for every kid, right? All right. So for today, I got to order that you be detained. Get back to level 102. Maintain it for me. Will you do that? All right. Thank you, sir. All right. Nathaniel Trenton Morales. Mr. Lahara, what brings Mr. Morales to court today?
Your Honor, he was referring in custody on the 25th of June on bodily assault causes bodily injury in a family member. It was father. Basically, the report tells us that Nathan and his father got in a physical altercation over clothing. Father removed his belt to physically punish Nathan. In the altercation, Nathan grabbed Dad by the neck, punched him in the back of the neck and his back. The report also tells us that Nathan is claiming that he was acting in self-defense because his father grabbed a cord and was hitting him with it. On the 25th, we had a detention hearing with Judge Kim. He listened to the information we gave him and indicated he would not release Nathan to either his father or mother. He asked me to try to locate a relative or a family member. I made phone calls. His paternal grandmother called me back and clearly indicated she would not be willing to take him. She also said she had no idea who would take him in the family. I contacted the CPS hotline on the 28th of June, told them Nathan has no place to go. I need them to contact him and find a place for him to live. And yesterday I spoke with the assigned caseworker, Ebony Mobley. She indicated she would be here today, and she's right here with us right now. And so is father. Father is present here.
All right, Ms. Mobley. Tell me what your office has been able to locate.
Well, we found a couple of placement options, which I did ask Mr. Ramon yesterday. Because we don't have custody of Nathaniel, they wanted him to call in to do the intake.
They wanted Dad or Nathaniel?
I'm sorry, Mr. Ramon.
All right.
The dad to do that, sorry. There are a few emergency placement options that we could look into. When I spoke with Dad yesterday, he also said that he does not have any relatives that would be capable of taking Nathaniel. So that's kind of where we are right now, is just seeing what's going to happen today so that we can move on to the next step.
Okay. Talk to me about a time frame for you, for your office.
You know, I kind of just jumped in on this.
Right. That's why I'm.
But maybe, it could be a week. Some of those places, they work off of, like, the intake process takes a couple of days, 24 to 48, sometimes 72 hours to have a turnaround. Some of the emergency placement options can work a little faster. So it just, depends on what's going to happen here, and, yeah.
All right. Ms. McGonigal, what are your thoughts?
I guess I would like to know from the department if they're thinking about doing an actual removal, or if they're going to just do like an FBSS case.
Go ahead.
Do you plan to remove the tag of this home, or are you just looking at FBSS, closing out your investigation?
Initially, we didn't have plans to remove Nathaniel. I guess just FPSS and seeing, the plan is always to, unify them.
Mm-hmm.
And Dad is willing to, do that. So I think that's a good sign, as long as Nathaniel is willing to, make that attempt too.
I noticed that they said mediation was available. I don't know if that's been discussed. I remember this case. I sat in on the last time for the detention hearing, so I remember this a little bit.
I remember, Nathaniel.
Yeah, so I'm wondering if mediation is available still, and get that set up. The mediated agreement, along with FBS services, I think we've got enough coverage and safety net for the family to keep him in the home, provide services pending coming back to court on this, whatever happens in the courthouse on this offense. I think that would be the best thing, letting him go home with that mediated agreement. I'd like to get that set up, if that's something the family will do, as soon as possible, and just go home after that.
Your Honor, we have approached Father about mediation.
Mhm.
We declined it.
Okay.
Mediation.
Well, let's pursue a dual track right now, because maybe after FPPS is going along for a little bit, and maybe if he's found an appropriate emergency placement through y'all, maybe some of those intervention services will bring everybody to a place where they're ready to discuss mediation. But Ms. McGonigal, sounds like we're not there yet. We may need a little bit longer. Time may heal some of the wounds. They're still a little raw right now. So I'm inclined, Nathaniel, I'm going to go ahead and order that you be detained today, all right? But you're at level 1-0. That's not lost on me. I need you to maintain that for me, okay? Because that's going to be a prerequisite before I'll consider you released to CPS. But you're going to have, I'll give you 10 business days. So if you get something sooner, notify Ms. McGonigal, and then she will approach the court and we'll do something. And as long as you're 1-0, then I'll consider release to that emergency placement. But if you're not level 1-0, I'm not going to release you. Does that make sense? Okay. The reason why I want you at level 1-0 is because if I know if you can follow the rules in the back, then you're more likely to follow the rules at the placement, all right? And that's what we want to see for you, all right? Does that make sense? All right. Well, that gives you enough time?
Yeah.
All right, Ms. McGonigal?
I'm actually not his attorney. I just happened to be attorney the day, the last time, and today. So
Right.
I don't know who his attorney is covering the case. Who's actually his attorney record is.
I have full, Trent, but I have full faith in your ability to communicate everything well. So, all right, that's going to be the order of the court. Thank you, everybody. All right, all remaining hearings for today involve children under the age of 14. Section 5408 of the Texas Family Code provides that when the child is under the age of 14, there's a presumption that the child's right to privacy outweighs the public's interest to participate in or observe such children in their detention hearings. There's been no evidence brought to the court's attention that shows that the public's interest to participate outweighs the privacy rights of the child. So accordingly, the court will discontinue the live feed. I want to thank everybody who's been watching at today's hearings. It's important that our public be involved in observing our governmental operations. And so I thank you for participating in that fashion today. If you enjoyed today's hearing,